May it please the Court. My name is Bill McCabe. I represent Harold Sipe, and I'll reserve 3 minutes for rebuttal. In this case, we submit the Judge of Compensation Claims erred in finding claimant had the responsibility of exhausting the managed care grievance procedures before filing his July 15, 2009 petition for benefits, and therefore the judge erred in finding he lacks subject matter jurisdiction to hear the claim. 440-192-3 does provide that if the employer elects to provide medical treatment through a managed care arrangement, the claimant has to exhaust the grievance procedures of that arrangement before he can file a petition for benefits.
And there's no dispute here that there's a managed care.
Correct. The carrier has a managed care arrangement. But we submit that the employer carrier failed to establish its affirmative defense that claimant failed to exhaust the managed care grievance procedures before filing the petition for benefits because the medical benefit claimant is seeking is not a grievance within the employer carrier's managed care arrangement. The claimant was seeking in the July 15, 2009 PFB an orthopedist in Melbourne, Florida, because the claimant moved there in June 2009. The claimant already has an orthopedist in Winter Park. So what the claimant was seeking was just a change in providers. He wanted a change from the orthopedist, from Dr. Stewart, who's in Winter Park, to, or maybe Orlando, I don't know, but that area, to a doctor in Melbourne. Now, the employer carrier's grievance manual specifically states, when it's defining what a grievance is, initial requests for medical services, second opinions, or changes in providers are not grievances. So we submit there was no grievance procedure to exhaust. Now, the judge interpreted that language to relate to care that is a matter of statutory right, such as initial requests for medical treatment, second opinions when allowed by the managed care plan, or the one-time change in physicians that the statute gives claimants, as opposed to medical issues on the appropriateness of care. And our argument, our response to that, of course, is the interpretation of a contract is a matter of law subject to de novo review by this court. We submit there's no ambiguity in the grievance plan. It doesn't limit the phrase changes in providers to just the one-time change as provided in the statute. It says changes in providers is not a grievance.
Now, I'm looking at the Begin, I don't know how to pronounce that, versus DBPR case out of this court in 2003, where we walked through, the grievance procedures in Chapter 59A of the Florida Administrative Code. And assuming that your interpretation of that phrase, initial request for services, second opinions, and changes, as I look at the procedures set forth in the rules, it appears to me that if it's not a grievance, it's a request. And the request is submitted, and the entity has to evaluate the request within 7 calendar days of receipt. If the request is denied, or if the entity fails to respond, it then becomes a grievance and then goes through that process. So even assuming that your argument is correct, the rules indicate that it still needed to go through the process that a request would go through to be either denied or not acted upon. Can you help me with that?
Well, in the Begin case, there was no dispute but that what the claimant was requesting did constitute a grievance with the managed care arrangement, if I remember the case correctly. And that case, Begin, found that the claimant, if I'm not mistaken, did everything he could under the grievance procedure and therefore was allowed to file his petition for benefits. But in this case, if a claimant is seeking indemnity benefits, temporary total disability, and there's a managed care arrangement, there doesn't have to be any request or any grievance because it's got nothing to do with the managed.
Benefits, right?
Right. Well, I'm saying basically that this is the same thing. This is not a grievance according to their own definition.
But you're seeking medical benefits, right? A change
It
in
is seeking a
physician.
medical benefit, yes, but it is seeking a change of physician or change in provider, I think is the language in the grievance procedure. It says it's not a grievance. So if it's not a grievance, then I submit there's no grievance procedure that needs to be exhausted. I mean, their own. Maybe I'm misunderstanding something. I mean, if it is considered a grievance, then I admit that the claimant obviously didn't do what they needed to do to comply with the grievance procedures of the managed care arrangement.
Yeah, because I mean, as I'm reading through the explanation of the procedures in 59A, I read it to say that to provide that basically if it is not initially a grievance, it's really a request for services or whatever. In your case, or in your client's case, a request for a change in physician and treating physician. And that request needs to be acted upon within 7 calendar days of receipt. And if that request is either denied or not acted upon within 7 days, the claimant may then either make a complaint or file a written grievance. So it seems to me that at some point the grievance procedure comes into play, even if it's not initially a grievance or a matter to be grieved.
Well, perhaps I'm wrong, but I thought that it's only if it was a benefit that you were seeking that their managed care arrangement stated you had to apply for them first, basically. And I'm submitting here we don't have to apply to them first to ask for a change in providers because their own managed care arrangement says changes in providers are not grievances. So,
but isn't that language in the managed care agreement identical to the language in the administrative rule?
To the administrative rule?
Yeah, I think that the rule has a provision that says initial requests for services such as requests for medical services, second opinions, or a change in providers are not considered a complaint or a grievance. It seems to me the language in the MCA probably derived from the rule.
It may have.
So if it takes a request that's not a grievance, but if 7 days passes without there being a response, then there can be a grievance.
Well, you know,
that's what Judge Marcello was saying.
I mean, I may be way off base. I don't know, but their manual provides also. It says a complaint or a change in provider is not a complaint either.
Right, and the rule says that too.
So, I mean, I see what you're saying. You're saying that if they want the benefit, even if it's not considered a grievance initially, if it's a medical benefit, they have to go through the managed care provider first, is what you're saying.
Right, and if there's no response in 7 days, then you've got something that you can file a grievance on. That's how I read the mechanics of this.
All right. Well, you know, I
may be wrong. I'll go back and take a look at it again, but that's how I read the rule.
I don't recall that, you know, I don't recall that argument being made in the briefs by anybody, really. Maybe I'm, but so I may be off base, but I mean, I'll just tell you what my position is, and obviously you tell me if I'm right or wrong. But my position is that since their manual states it's not a grievance, there's no grievance procedure that we even have to comply with. Now, if I'm wrong on that, then I'm wrong on that. The subject matter jurisdiction issue, I found kind of interesting. I mean, they said we waived it because it wasn't brought up until the motion for rehearing. There's cases that say you can't waive subject matter jurisdiction and you can raise it at any time. Every case I found in subject matter jurisdiction, which I find kind of interesting, is always from the defendant's standpoint. They're the ones raising it. I couldn't find a case where the plaintiff was arguing subject matter jurisdiction. But again, this is kind of a strange wrinkle in workers' comp, because if there is a grievance procedure, the claimant's got to follow through in order to give the judge subject matter jurisdiction, or contend that you don't have to go through the grievance procedure at all, which is what we did here. So,
but did the petition for benefits filed in this case allege that the grievance procedures had been exhausted?
You know, I think it may have, and quite frankly, the claimant thought initially that the grievance procedure did have to be complied with, but then they realized They didn't think it did. And they filed with a motion for rehearing, and our argument on that is that you can't waive subject matter jurisdiction. So even though it wasn't brought up until after the hearing was held, that's okay, because it deals with subject matter jurisdiction. So that's
Even though it's an assertion that it exists.
correct. But what's good for, if they can assert that it doesn't exist at any time.
But you're right, I've never seen a case that talked about how you can raise subject matter jurisdiction that it exists, but it does always just talk about it in a generic phrase of subject matter jurisdiction.
True. I mean, I hunted for a plaintiff version and couldn't find one. Thank you.
Good late afternoon, Your Honors. May it please the Court. My name is Lamar Oxford. I represent the employer carrier here. And before I discuss the individual facts of this case upon which the Honorable JCC wrote a very good and detailed pair of orders, I'd like to back up and just briefly discuss and make fair comment on the history of managed care. I think everybody in the system knows that the legislature authorized it to try to have an impact on the massive amount of attorney's fees that play at the risk of shooting my profession in the foot, that played a large part in the increase in workers' comp premiums. I think that was one of the driving forces behind managed care, to lessen the number of medical benefit only claims before judges. And there's an attorney's fee component to that, unquestionably. That's why managed care was created and authorized by the legislature, to get these medical treatment disputes in front of a grievance process, or through a grievance process.
Well, what about the manual that tells the employee a claim, a request for a change in physician is not a grievance?
Your Honor, I'll quote that controversial issue. Quote, initial request for medical services, second opinions, or changes in providers are not grievances. Initial request. Everybody gets a one-time change in provider. That's statutory right. That comes right out of the regulations. And of course, that harkens back to another argument I have here, that and with great respect for Mr. McCabe, he wasn't the trial attorney for the claimant. That argument wasn't even made until they lost. That wasn't, the motion for rehearing isn't on subject matter jurisdiction. They lost, and they went searching for another argument that they could have made at the first trial. It's undisputed that the claimant already had the manual. His attorney ostensibly already had the manual. But at the trial, they essentially conceded that managed care applied, and they argued substantial compliance, Your Honor. And they lost for a lot of good reasons that I could detail here and summarize for you. And then after losing, they go back and say, oh, wait a minute. The manual gives us another argument. We'd like to raise it now. Well, it's time-honored law that it's only fair to the judge and to the other side to make the arguments that you have when you have them. And there's no question this wasn't new evidence. So it's no wonder that the judge found that that argument had been waived when he ruled on the motion for rehearing. But then he went a step further and probed it, and also detailed in the order why, even if it wasn't waived, as a matter of fact, it doesn't apply. Because that language lifted out of the regulation simply says initial requests for medical services or change in providers are not grievances. Brief history. This gentleman is looking for his fourth doctor. This is a case of doctor shopping, and it's a serious case of attorney's fee searching. I'll tell you why. First orthopedist for this low back injury finds him at MMI in May of 2009, 0 impairment. No more need for treatment. No wonder he didn't like that. He gets an attorney. He asks for his one-time statutory change in provider. We give it to him. New orthopedist. That doctor agrees. Already at MMI, gives him an impairment rating. We pay that. We pay those permanent impairment benefits. And that doctor says he only needs palliative care maybe once a year from an orthopedist. But that doctor also says he probably needs a pain management doctor to fill his prescriptions. We give it to him voluntarily. And yet, now he wants a fourth doctor. Well, then medical necessity becomes an issue. There's no statutory right to a fourth doctor, or in this case, a third orthopedist. So it has to go through managed care, which everybody concedes applied here. Because we have the right to go in there and say, this is not medically necessary. We could argue even the distance, which was the sole basis, ostensibly, for the request for a doctor, because he moved an hour away. I think this is a case where if the PCA doesn't beat Bill and I back to Orlando, that this is a really good case for this court to write a strong opinion about lawyers trying to avoid the managed care process with medical care only claims and going looking for doctors and going looking for fees. They still, Your Honor, they still have not tried the managed care, the grievance procedure. They still haven't even tried to exhaust it.
In the case that Judge Marstetter referred to, the Bagan case, which I noted wasn't cited in any of the briefs, and I'm sort of amazed that Mr. McCabe had recollection, but then I noticed that he was the appellant's counsel in that case. But in that case, we held that there was a claimant that made an initial request for, I think, a change of physicians or for medical services, which wasn't responded to, and then made a second request for authorization of a particular doctor, and we determined that the second letter constitutes a grievance. Okay? Two letters. The second one satisfied the grievance procedure and was a grievance, and then they can file their petition for benefits.
If once they give the employer carrier the 7 to 14 days investigation period to determine whether that grievance in fact should have led them to make a different decision, should have led them to say, okay. Here, we didn't even get that. You know, the facts here are that one day after we received the certified letter requesting this fourth doctor, he filed a petition.
Well, I only can go on the language of this case because it says, we say, in our judgment, claimant's second letter constituted a grievance, and the failure of the insurer to act within the time required under the rule creates a legal conclusion that claimant exhausted the required grievance procedures before he filed his petition for benefits. So,
I don't necessarily have any problem with that holding. I don't think it applies to these facts at all. I mean, this is absolutely a case of not giving the employer carrier the right to even investigate the medical necessity of this claim for a fourth doctor. One day after we received the letter, he files his petition and off we go. And no wonder that Judge Condrey found that there was a failure to exhaust, there was a premature petition, and that the claimant and his attorney himself conceded that managed care applied at trial. And so the judge found they failed to exhaust. So what do? They go searching for another argument, this ambiguity in the policy manual that's not even a contract. It's not really even a question of law for the court to interpret. We respectfully submit. There's just argument after argument after argument as to why the judge was right. But here we are on an extensive appeal, and they still haven't even filed a real grievance and allowed us to respond to it on this fourth doctor. So the judge did a good job in his order of saying, they're wrong here, no jurisdiction. But even if, then they're wrong here for this reason. But even if, then they're wrong here for this reason. So this case should have never gotten this far. It should be back in the grievance procedure. But claimant's attorney thought he could just ramrod it through and make a fee off it, and a trial attorney. And I think the judge saw right through that. That this system in the state is set up to try to keep these medical benefit-only claims away from the judges if they can, through the grievance procedure of managed care. And it was not complied with here. The judge saw it. He wrote a detailed order both times, even on also on the motion for rehearing. And we think it's virtually unassailable. The legislature authorizes it. You've got to comply with it. There's rules that apply. And if you don't get your satisfaction, then you can go in front of the judge. But this sort of ramrodding is, I don't think it should be allowed. I don't think it entitles anyone to a big fee. And we think it's what the legislature intended by managed care. Thank you.
I just wanted to respond to two things. The July 10th letter that was mailed to the carrier, they received it on July 14th. They still to this day haven't responded to it. So, and the carrier did provide medical treatment excellently without question until the claimant moved to Melbourne, and for some reason I guess that's where the line in the sand was drawn. Even though Dr. Stewart, who's the orthopedist in Orlando Winter Park, and Dr. Malzadeh, the pain management physician in Melbourne, both indicated it was medically necessary for the claimant to receive orthopedic care by an orthopedist in Melbourne, and the judge indicated that's how he would have ruled had he gotten over the jurisdictional issue. Thank you.